rights, now we're getting into defamation, so, but if you have a question, okay, one question.
Okay, what happens after you get that cease and desist letter?
I'll send you a copy of the letter, you can
David Barsky.
If it says govern yourself accordingly, that's when you go to the attorneys really mad.
All right, why are those letters sent? Okay, I represent associations, so I've had to send similar letters. I try not to use that govern yourself accordingly anymore, it's a little tired, but it's a very popular one to end the letter with. Why do we send them? Because when you're going to enforce your governing documents, and even more specifically when you're going to go to arbitration, because remember there's certain disputes in condominiums that go to arbitration and other ones that go to court. The ones that go to arbitration, the arbitrators are very clear that you cannot file an arbitration action unless you have first given notice of what the alleged violation is and a reasonable opportunity to cure. So typically when lawyer letters go out that say that, it's because there's an allegation that's been sent over from the association that somebody is violating some provision, and you're sending that out on behalf of them to let them know the specific provision that they violated, giving them a reasonable opportunity to cure so, or cease and desist from doing so before you may be pursuing further legal action. Because if you don't do that first and you just file your arbitration, it's going to get dismissed.
I thought they were going to do, I thought they were doing away with arbitration. Did you hear that?
Really?
Yeah, they want to do away with arbitration. Okay.
Yeah.
Dan, go ahead.
Before you don't know that, yes, arbitration's may be a thing of the past. There's something moving through the state legislature to take down that entire system.
Oh no. Well, the other thing is you got to remember when we're talking about arbitrary capriciousness and enforcement. You need to have a record that you're doing something. I've had to send cease and desist letters because I tried calling the other side 3 or 4 times and they just didn't answer. So I sent them the letter. You know, they go, "Oh, you sent this letter." Well, you shouldn't send my voicemail, right? Because I was trying to reach out to you and I just wanted to document that whatever enforcement it was. Because again, in the intellectual property world, very much there's a lot of crossovers with condos, and a lot of things are very similar. You have to police your marks. You have to make sure you maintain your brand. So I might find somebody, I might say, "Hey, look, I'm a little worried about this, what's going on here?" And if they don't respond, then yeah, I'll send a letter like that to get them to actually respond to me. And most of the time, we're able to work something out pretty easily, but you do have to have that documentation there. It doesn't necessarily mean when you get a lawyer letter that it's going to be hostile. It may just be, "Hey, look, I'm documenting the file, making sure I do everything that I'm supposed to do. And I've got a record that I did it," and then we close it out because it's just a little thing. Maybe not, maybe you're really in trouble, but don't ignore those, right? And because that's where usually, if you just sit there and ignore it, that's usually where bad things are going to happen, or it's going to get escalated. And once things get escalated, it has a real tough, real interesting way that they don't come down as easily as they get escalated.
Oh, you can put them in their place.
Let me ask the question the other way around. Before you get that cease and desist letter, aren't there grievance committees and things like that in that
Should be.
condo? Before you get to that point, what's happening?
And that's impossible to answer because every community is different and every person is different. Certain types of things. Okay, I think when you were asking about a committee, if you're trying to fine somebody for an alleged violation of the governing documents, there's a statutory procedure you must follow to pass the fine. You have to give them an advance notice, 14 days in advance of a properly comprised fine enforcement committee. But a lot of associations don't even do fine. Typically when you get those cease and desist letters, it's letting you know you're violating the rules, you better stop, or they're going to pursue the matter in arbitration or court. What could have gone on before? Anything.
So that's interesting, that's the predicate, right? You do the cease and desist because you're laying the predicate for a future action, whether it's arbitration or litigation. That's why that. And how much fun are cease and desist letters? Who can attest to how much fun they are?
I love them, they're challenging.
Well, that's an interesting perspective.
I hate them because they want to shut your mouth.
But they can't.
Is that First Amendment?
So, okay, so we we got some more comments here. Okay. So, next question. What is defamation and how does it apply to the condominium setting? What is the difference between slander and libel?
I only know defamation, so you're gonna have to explain the other two.
Well, the other two are just part of defamation. Slander and libel is just whether it's spoken or written, okay? So overall, it's called defamation, and you know, whether you say it to somebody or you write it down, both of those are defamation. So what is it? It's publishing. So if I think it to myself, or if I just turn to the commission and say, oh, that person, blah, 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 right? Okay, publishing, you gotta put it out there. So I can have my private thoughts, et cetera, but it's gotta be put out. Now, it doesn't have to be broadly distributed. It can be distributed on a very, very small basis. Even just me saying it to the commissioner might be publication in certain instances, but it's the publication of a false statement about another. So you can't run around, and people get really cute about this, right? The classic example is, you know, so when did you stop being your spouse? Well, I just asked a question. Well, you didn't just ask a question there, right? Because you inferred the answer. You inferred really the crime, right? Spousal abuse. So that's trying to get cute with this. Well, I didn't make a statement, it was a question. Now it has to be a statement of fact or what you perceive to be fact. So things that are opinion statements are generally not actionable. But again, don't try to get cute with, well, it's my opinion that blah 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 blah. Right? Just like with the question thing, you can't turn a statement of fact into a quote unquote opinion just by saying my opinion. Okay? Because they'll look around that. Otherwise, everybody would just say, well, everything's my opinion. Wink, wink, nod, nod. So it's the publication of a false statement, written or oral, is the definition. The difference between libel and slander, but again, they're both considered defamation of another. And then the last thing is the damages resulting from that. That gets into some really questionable.
Are you Facebook? Are you talking about Facebook too?
Facebook is publication. Facebook is publication, right? If you put something on Facebook, you can name somebody on Facebook. Now, because again, that's really open to just about anybody who wants to see it, right? So that's definitely publication.
What about flyers?
Flyers are publication.
Facebook, Twitter.
Yeah, all of that is publication. You put it out there, it's a published
We
statement.
didn't have Facebook when we were undergraduate.
Yeah, well, there's a lot of things. There's probably a lot of things that a lot of people are happy that they didn't have Facebook for when they were in school.
What about a WhatsApp group chat?
That's publication.
What if it's 100% correct information provided by the city of Aventura and verified by the city inspector?
It's not a false statement.
It's not a false statement, so I can share it.
The truth will set you free.
The truth will set you free, but keep in mind, don't, again, be straightforward with things, right? My themes that you were getting here, don't take a true statement and try to twist it into something that is not true. Okay, let me give you an example. This is a case that I tried. This was in Palm Beach County for Palm Beach County Commissioner elections. One of the candidates went and found a police report about my client, and they published it. They thought it was about my client. It just happened to be somebody with the exact same name. But if you looked through all of the public records, you would see that there was a difference in age of, I don't remember what it was, about 20 years, a difference in height of about half a foot. But that wasn't on the top level papers. You had to dig down through that. So this candidate put out there, is X a convicted criminal? Question mark. There's the making the question, right? It's saying, I'm just asking a question, not making a statement. With the arrest record that had the other candidate's name right there. Absolutely true. That person had a criminal record. They happened to have the same name as my client. That was not my client, right? We actually got through most of the jury questions on that issue. And if it had not been a public figure, if it had not been a public figure, that case would have been decided in our favor. So it's, right, that's what I'm saying, true statement, it's a police record. Everything about that is this, and they tried to form it as a question, is this record with the same name? And the jury found that was, in fact, a false statement. It was a defamatory statement.
Can I give you an example, and you tell me if I'm correct or not?
That's the me not providing legal advice part
No,
of
just
it.
I mean, here in Aventura,
I'm going to give you real life settings about how I usually see defamation cases come in when you're a board association attorney. Typically they come in against a board member from a unit owner, and I don't really get involved because if you're going to be on a board, you're going to have insurance, and you're going to get insurance defense appointed counsel. And I'm going to see a little bit about the case, but again, like you just went through the elements, it has to be a false statement about the person directly, published in some manner, and it has to have caused damages. And that fourth element I haven't really seen followed through on in much case law, because what constitutes damages? Is it damages that you have to live with the shame of your neighbors having heard this? Is it damages if you lost an election for the board because of it? And how do you quantify that into money damages? And most of these cases end up settling out because there's insurance dollars involved, so I haven't seen a lot of opinions. Do you have any opinion on that?
Sure. Yeah, that's the really hard part. I'm not an insurance lawyer. I've tried these when it's been private dollars at issue. And what is the damage, right? Now, if you accuse, it's called malice perception. If you accuse somebody of committing a crime, they don't have to prove damages at that point, right? Because it's presumed. If you accuse somebody of committing a crime, of being a criminal, you've presumably harmed them, right? As long as the statement was not true, etc., everything else is met. So, if you don't accuse them of committing a crime, and like the Commissioner asked, what are the damages? That's really hard to say. I mean, just truthfully, people will go out, they'll get experts, and a lot of times it does settle because there's an insurance company involved, and they'll go, all right, it's just, we'll negotiate some number behind closed doors, we're not going to tell anybody what it is. But that's very much an open question. And now that doesn't mean that if you were ever sued and you went to a trial and everything, and the jury wouldn't come back and say $1, and okay, well now you've just been found, you've just lost the case finding that you defamed somebody else, which probably not a great thing for you. On the flip side, juries are weird, and you don't know what they're going to do. They might come back and go, wow, that was really horrible. I really dislike that person. $1 million. That can happen. So that's a crapshoot. If you're in that position, it can go in any range of possibilities.
Would you repeat the term? What's the statute of limitation on defamation?
Oh, I think it's 5 years. I'm trying to remember.
That's good.
I think it's 5 years.
So you assume that homeowners defame others, but what if the board signed a defamation letter that was published against a homeowner that reviewed documents threatening the board of alleged fraud? What do you do with that case? 4 pages, published emails, posted in the mail rooms, put under the doors, and damages when you live in a community is 100% damages when your name is ruined and you have to live there forever.
Or your home is valued because people keep saying things that are.
So
You could try to convince a jury, that those are there's damages associated with that, and try to quantify it. It's no different than, what are pain and suffering damages, right? I mean, if people go and say, oh, I've got pain and suffering, what's that worth, right? And we all try to come up with a measure for it.
The difference with those cases, when it's an injury, like there's doctors that come in and experts that give opinions, you're 8% disabled for the rest of your life. These cases, I have a real curiosity because I don't think there's a good guide in case law as to what the damages are worth.
Yeah, there's no guide on that of what the damages are worth.
But this brings me to the main reason that I came to discuss the Homeowner Whistleblower Act, which we must look at the encouragement of owners to speak up, to review documents, and not be intimidated by bad apples. And there is no statute that protects a homeowner for intimidation of bad apples on a board. The other problem is that it's very hard to unite a community to stand up. And the major problem in all these communities that we discuss right now is that we need to teach and educate owners to unite and stand up. We don't have that, and they don't allow you to unite because they can use mails to email everyone, but we as owners, we can't. And it's hard to knock on the doors, and it's hard to unite, but if we work, and I wrote to 13 members, legislators, you name it, to work on legislation to protect homeowners the same way that the whistleblower in an employment setting is. And that will protect us and prevent fraud because they would think twice. And we need to do something about that. And that's why I came. I hope you're going to unite about that.
For me, those are very valid points. In fact, Senator Pizzo, who was keenly interested in this, these are the types of things that we're going to report back to and talk about some potential policy solutions to address
I
that.
hope so, because I wrote a year and a half to everyone, and I have a list of 13 from the governors to representatives, and nobody answered. It's really unbelievable, because nothing in the state laws that you're going to change will protect us from fraud and intimidation. It's only when the owners are protected and united, and we are the power in not a board member, 7 of them or 5 of them.
Okay.
I'm going to answer a little bit. I'm going to take a step back. You're all owners, I'm presuming, that live in condos. You can all run for the board. I get calls multiple times a week from distant friends, cousins. I'm Cuban American. You hear from third and fourth and fifth cousins you've never even met. My board is bad. This is a typical call you get. My board is bad. My board is spending the money, I don't know how, and I can't do anything. I give everybody the same advice that I'm going to give you tonight. Run for the board. And let me finish, and then you can tell me what the problems are.
Our
And
last board was, they cheated.
Okay,
So
I'm gonna get there. Let me finish what I'm saying. This is the problem sometimes at board meetings. Everybody wants to talk over everyone. Okay. The number one thing you can do if you want to have a voice and you want to have a control of your building is run for and get elected to the board, because the way that the state law is set up, not the city law, we're local commissioners. 95% of what you do is governed by state legislators, and they have determined in the statutes that those decisions are made by the elected board members, except for finite things, you know, like waiving reserves, amending, whatever, material alterations. You all know what those items are. So if you have a truly bad board, you need to try to get elected. Now, I think what you're saying is there's some tools that make it difficult for certain unit owners to get elected, as opposed to the entrenched boards that's there. Things that make it difficult to campaign, to communicate with unit owners, to get out there, and we'll discuss some of those things, and maybe where there's some legal changes that need to be made. But I can tell you, having run an election, and I mentioned this to Dana last week, when I get out of this business, I'm going to start a condo election business. Because the real problem is people don't know how to win the elections. So they spend energy, in my opinion, this is my opinion right now, doing a lot of things that don't help them. It's not necessarily helpful to spend hours and hours a day putting out YouTube pages. It's not necessarily helpful for you and your building to run around and just try to malign the association without the facts that back it up. What people need to do is they need to learn how to reach the other owners, to communicate directly with those decision makers, and be able to prevail and get other people elected. Because if you're having those problems and they're so bad, there's other people that are having them.
They won't let you, I have to say it. We talked to our management about how we can add seats for our huge building and how we can run for the board. 2 weeks later, we got a cease and desist. We put in our application, we got sued by the building. We were called village morons, village idiots at the board meeting, humiliated. the real deal about my family. Every single employer my sister and I have gone after has questioned us about that. So if you want to talk about the implications of that, they're huge. We don't have a single friend left in the building of 361 units after 20 years of owning 2 units there, because we decided to run for the board finally, because we saw what was really going on there. So I'm sorry, they won't let you. They go to their neighbors with bottles of wine, they tell them not to come to budget meetings, and that they'll fill them in. Really, with due respect, you just don't know what's going on there. It's crazy.
So I'm going to take a little bit of the contrary view to Michael, because, and I'm going to throw it into a hypothetical as well. If we, as unit owners, can't even get emails from our association, how are we going to be able to communicate anything? We can't even get an email because an email is privileged and protected from the official records mandate under the statute. Isn't that the case? We can't even get the emails. I mean, the emails, you can make a public records request in City Hall and you can get all the emails that are in City Hall. Why can't you get them in a condominium?
This is one of the areas where condominium living differs or diverges from being a municipal representative. As Dana mentioned, we're both in local government. If people want to get all my emails, they can send the public records request, and they can see whatever the commissioners are doing. I assure you mine is pretty boring. But in a condominium, the way that the state law is presently written and interpreted through DBPR opinions, unit owners are not entitled to request the email list. And that is a source of contention amongst a lot of unit owners. And I have different views from my law firm, from other law firms, from being an individual. I'm not at the state, and this is not an issue, but I think that if an association is communicating via email, that it would be fair for the unit owners to have access to emails. I'm about equality and everybody being fair. So that's my personal 2 cents, but that's not what the law is.
We have a hard stop at 8, and we have plenty of material to cover. So I want to wait for the questions until we get through a few more topics.
Sure. I have a question that can be answered yes or no. It takes 2 seconds.
My students say that to me all the time.
Mr. Becker, if a judge made a decision in, say, state court or federal court that somebody else didn't like, your recommendation would be become a judge? Yes or no? That's what you're telling us with condo owners, to go run for the board. That's ridiculous. So is that a yes or a no? Would you recommend that you run for a judge if you don't like what they're doing?
Some of us recognize, some of us in the audience actually, we do recognize that it's sometimes very difficult. I know it's a very standard comment of an association attorney to say, run for the board.
Shifting the board on the
Run for the
responsibility
board,
on the owner.
elections come.
It's not the owner's responsibility, it's the board's responsibility.
But it is, in certain condominiums, it's difficult to get a seat on the board. We have the new term limit legislation, and even with that, there's been a big discussion about retroactivity, whether those term limits start today or they start in 8 years from now. Now the DBPR has taken a different position, so it's what, 2022 until those term limits. So that combined with the fact that unit owners have no ability to communicate with other unit owners because it's not feasible to go door to door and because we don't have emails, there's definitely an understanding that not in all cases can people just run for the board and get a seat on the board or get a seat at
That
the table.
answer seems to completely discredit you as somebody I would take advice from. I'm sorry, but that's absurd.
Because it's not always easy to get a seat on the board.
No, his advice, if you don't like what's happening, run for the board. That is the most ludicrous statement I've ever heard an attorney say.
Well,
Yes, I have no respect for that whatsoever. That's absurd. That's not the solution. I can't run for the board, but there has to be a solution for what the board is doing. Making a statement like that makes me know you are an association lawyer, not a lawyer for the people.
Well, it's actually a position that a lot of attorneys. Let's get through some of the materials because we do want to get through some additional information here, but.
I'm going to tell you what happens a lot of times. People get very angry. I don't know what issues or baggage you're coming to the meeting with and why you're angry with your association. I've just met you tonight. But what happens is people come a lot of the times to the board meetings with all of this anger. It might be justified. But instead of being able to coalesce and have your neighbors come around and want to assist you, your frustration becomes a turnoff to other people. And then they don't want to support you.
Again, it's the actions of the board that
This is the reason why we wanted to get through some of the content and some of the materials, so if everybody can hold their questions until the end.
But it's relevant. Let me just answer. What he offers is in a normal, honest community. But many of us here does not enjoy this type of environment, unfortunately. In my last election, I proved one-to-one the violations in the last election that we had based on state laws. What you should, what you can, and what you cannot. One by one, the association attorney did all the problems because he protected the handling of a fraud election. So what do I do then? It's a problem. It's not a normal community that you're talking to. That's the main problem. We need solutions in state laws and liabilities, and we don't have that.
Okay, we're gonna. Your point is well taken, but we have a lot of additional materials to cover. We're trying to go. Okay.
My name is Martha Alvarez. I'm a property manager, on the camp license manager. I come from Washington, D.C. area. I moved here 4 years ago. And yes, Florida is very screwed up. I agree.
Oh my God,
However, I do want to tell you, there is light at the end of the tunnel. I've helped 3 communities now. I'm not a lawyer. I'm not giving you legal advice, so let me just disclaim that. But there is a light at the end of the tunnel. What they are saying, and I know there's a lot of frustration. I hear it every single day. But there is a light at the end of the tunnel. I've had boards and worked with numerous associations to throw the old boards out because of the hostile environment, because of the illegal things that are being done. And yes, have even filed things against attorneys with the Bar Association because of corruption. So you can get it done. It's all about community. It's all about things. So I understand what you're saying, but understand what they're saying. A lot of homeowners are not educated on what they're allowed to do and what they can.
They can run for the board, right? Yeah.
Okay, so everyone, we're here to talk about First Amendment rights and First Amendment issues. So I know we've digressed a little bit. So can we continue with the discussion of First Amendment and defamation, other issues, and then we'll circle back because we're veering off into elections and fraud, and our topic really is about First Amendment rights. We can always have another workshop and focus on those issues, but for the purpose of this evening, we really want to continue with First Amendment. First Amendment.
Who does the association attorney work for? Because here's the thing.
It just depends.
They work for who pays them.
It depends because the association has a retainer agreement with the attorney. So you want to speak to that?
Listen, I know that there's people here that are upset with your associations, and you may well be justified. I don't know your particular situation.
But you have to stop saying things like upset. You have to stop saying things like issues. You have to stop saying things like baggage, because we're coming with real problems. We're not coming with issues.
I know, but what a lot of people need here is they need to consult with an attorney specifically about their claims that they may have. We're here talking about general principles of law. And general principles of law is everybody in the association is a member. The board members are members just as the unit owners are members. Everybody's a member. I've been on a board as a unit owner, I've been on a board as a board member, I've been in a building where I like my board, I've been in a building where I don't like my board. But the way the law is set up, it's just like government is set up. People run, they get elected by the majority of the qualified voters that come out and vote. And then what happens is maybe your building is making it difficult for you to get elected. I don't know, I'm not opining on that issue because I don't know your specific circumstances. But the way it's supposed to be set up under the law is for the majority to select which particular unit owners are going to represent on the board. If there's obstacles being set up to do that, then that would be inappropriate. But I think what happens in some cases, when people call me, they don't know how to win the election, which is a bit of an art.
Michael, a lot of us you have,
here to share the First Amendment.
Yeah, we want to, let's continue, everybody, let's continue with First Amendment rights. Okay, so my question, which I think is a very important one, I want Dan to talk about that. Are the board members of my condominium association public figures or private figures? Can I say whatever I want about them? And what about the property manager? Is the property manager a public figure or a private figure? Does that make a difference?
Look, it depends, right? Because there's public figures, there's private figures. Okay, so what's a public figure, what's a private figure? A private figure is my neighbor who none of you know, right? A public figure is, one of the Kardashians. There's different standards between what you can say about a public figure and a private figure, right? Private figures, no matter basically anything that whatever you say is going to be, that's false, would probably be defamation. Public figures, on the other hand, because you put yourself out there, you have opened yourself up for attack, and the standard is going to be different, and what's going to, what you would have to show and the egregiousness of what happens is a different standard for a public figure. They basically take a lot more abuse. Now, what are board members and what is the property manager? Are they public figures or private figures? It's tough to say because it's going to depend on your particular circumstance because there are things called limited public figures. Right, so Kim Kardashian being a reality star or whatever the heck is the term is these days, public figure pretty much for everything, right? But then there are limited public figures. Various people would be considered limited public figures on certain things because of what they do. They're an expert at something, they're on TV. So these people you see on the news as the person that the news channel goes to be the expert in the local real estate market or whatever other thing. You see them pop up on the news, whether it's the local news or the cable news or whatever. That person's probably a limited public figure because they're putting themselves out there for some narrow topic, just not generally their entire life. So board members, again, it depends on how they act. If they're out there campaigning and doing all kinds of things, they're making themselves, and I am the condo expert or whatever it is. Let me tell you how it is in a broader scope, so that they're fielding questions from other people, right? That may be a limited public figure, meaning that they're going to take a lot more abuse. However, I think a court's most likely going to find that your condo board is going to tend to fall more onto the private side, which means that the standard for what is said about them being defamation is lowered because a condo is usually going to be a closed dispute. It's going to be amongst your community members. It's not going to be somebody who's out there in local politics or on the news channel and seen across Miami, Broward counties, etc. And so that's where it's possible that they would be considered a limited public figure under certain circumstances. I can conceive of some situations where that might happen. I think in most circumstances, they're going to be a private individual who is going to receive more protection from the law from anything that you say about them that is defamatory.
Just a 2 cents on this, because I don't think it's clear under Florida law, but my opinion on how I've read the cases is most condominium board members are private figures. I don't think by virtue of running to be on a private board of a private building, you've necessarily sought out to be a public figure under the interpretation that the law has.
Property managers.
I'm sorry, I didn't talk about property managers.
There's a case that says the property manager can be.
Yeah, sure. And that's going to be, right, so when I said it kind of depends, and I can come up with circumstances where the condo board person would be a limited public figure. If they were out there running all over the place, I'm the condo master, blah, 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 right? Okay. Yeah, well, I know, condo manager, whatever. Property managers, they actually do that, right? That's how they get business, is by going out there and marketing themselves as being, a lot of them, as being somebody who's highly developed at this. This is what they do for a living. That's going to be much more likely to creep into that limited public figure space because they are doing that. When it sounds kind of silly that an individual board member might be doing it, condo managers, the management companies, they are generally doing that as a matter of marketing their business. And so they may be a limited public figure, especially if it's somebody who's going and speaking on various panels, or they're going out there and giving talks, or they're going on, again, that's the person you might more likely see on the local news segment about condo issue. It's somebody from a property management company. Once you start getting into that area, then yeah, they're probably much more likely to be considered a limited public figure for defamation purposes. Again, it's all a sliding scale, it's all a continuum. If it's just, if I'm just me on a condo board, and I'm not doing anything, I just, okay, well, I won the election, I sit there, I do my thing, I don't, I'm going to be considered a private figure in that regard.
Are you a public figure right now?
Am I a public figure right now? I don't know.
You're in a panel. You're in a panel.
Okay, Professor Barsky, what is a qualified privilege? Does it apply? Does it matter? Do board members have a qualified privilege?
Okay. Yeah, qualified privilege. So now you're getting into things where, this is where you start getting into interesting situations. Do you have the right to raise an issue? Again, I know we talked a little bit about kind of some of the whistleblower, maybe are we going to get a whistleblower statute? I don't follow the condominium laws closely enough, but again, not everything is going to be, gets where it gets dangerous. Not everything is going to be defamation just because you raise an issue that's a legitimate issue, okay? We got to be very careful about, you can't just run around and say, well, I know you made something up or some crazy thing. I've seen a lot, I've seen a lot of stuff now in my local community saying, oh, 5G is dangerous. Just because you don't understand the technology doesn't mean it's dangerous, just because you don't understand it, okay? These things are known by experts in the field, just maybe you're not an expert. And I know in this day and age with Google, everybody's an expert on everything. But you are allowed to raise certain questions. You are in certain situations allowed to raise certain questions. But they have to be, again, it's got to be relevant. You can't just go around starting to make wild allegations in the form of a question, in the form of raising something that you think is somehow privileged, just because you want to say something bad about somebody, right? We're going to kind of examine behind the scenes there and see, is that, was it a legitimate question? Was it a legitimate issue? Was there legitimately fraud going on, right? If you say, hey, I think this is happening, if we're starting to get into almost into the slap realm now in some of these areas, because it all kind of blends together, you just, again, you gotta be careful with that. You can't have, the theory from like Homeland where, Kerry Mathison's got the board that goes on for 3 pages. You tie the string all over the place, and if you combine everything, the 50 different things together, and you look at it this way under a black lamp, all of a sudden, boom, there it goes. We know where Jimmy Hoffa's buried. That's probably not going to be considered privileged in any way. But if there's some legitimate thing going on, if there's a legitimate question out there that needs to be raised, you do have, in certain areas, the ability to make those statements that would otherwise be actionable. One of those things also happens to be, I'm getting kind of out of what some of the qualified privileges I think you want to talk about here, but in court, right? As an officer of the court, when I'm in court, I'm allowed to say things, right? Because think about it. Any case that I ever brought, I go, well, I think you committed fraud. I'm allowed to do that because of the setting, right, that I'm in. And if there's an issue, and like say you're in court and you're testifying as a witness, and they ask, well, what did you see? Well, I saw fraud. That's, again, those are going to be areas where that's privileged, because you're being asked to give your testimony. I know that's a little bit of a different.
Was that a factor in opinion?
Which one?
So what about the fraud? Was it a factor in opinion?
Well, if that's what you believe, that you're being called as a witness to testify, right? Because otherwise, the idea is that if you're in court, you got to be able to tell what you perceive to be the truth. Right? Trial is all about, there's your opinion, what you saw, there's what I saw, and then there's what actually happened. Right? Because there's all kinds of psychological studies about this. If you stop the people around the crash accident and ask them what color the light was, they're going to give you different answers, right? The light was only one color. But it's just amazing the way people perceive things. So in a court setting, now you can't go on a rant or anything like that, but if that's what you saw, if somebody asks you a question that the judge allows you to answer, And it's, yeah, well, what did you see, what happened, and you go, well, I saw this happen, and it's a crime, or it would be a crime. You're allowed to say that, because you've got to let people testify as to what they perceive occurred. Otherwise, what are we doing, right? I mean, you can't speak freely in that situation. You know, it's like in those military movies, permission to speak freely. In court situations, in investigations, things like that, permission to speak freely. Don't go crazy.
Okay, I have a few more hypotheticals, and we're getting close to the time limit where we're going to get thrown out of here. So, the board meeting last night was insane. Lots of shouting and screaming, and lots of name calling. Can the board be held responsible for what happened?
I'm not sure in this question who the people were, if it's the board or just the members, and chaos ensues. I don't think the way the question is worded that a board could be held responsible. But typically whoever's chairing the meeting, I believe, has some kind of a duty to run things professionally. Usually it's the president, sometimes there's an attorney present, and they have the attorney run the meeting. And I think somebody is responsible for maintaining some kind of order. And it usually works. In most buildings, you eventually get things under control. There are situations, and I've represented condominium associations where things just are always out of control. And where people, besides the fact that they're out of control, they use vulgar, vile, abusive, rude language. So those situations are perfect examples of what we're talking about tonight. Where does somebody's First Amendment right to express themselves in a meeting perhaps violate other people's rights or become a nuisance under the condominium documents? And that's an issue. And there are cases where you are allowed to bring claims for nuisance under certain situations where people's behavior violates that.
So that's an interesting point, right? Because a nuisance is something that you can bring in arbitration, but defamation is something that you can't bring in arbitration, right? The arbitration will not accept jurisdiction, the tribunal over a defamation claim, right? So which way does the nuisance flow? Is it really the unit owner? Is it ever a board member that you could say that, or it's always about the unit owner creating a nuisance? Talk a little bit about that and what the case law states right now.
Sure. Well, I represent mostly associations, so the few times that we're involved in nuisance actions are typically with unit owners that have repeated behavior. The gentleman asked about a cease and desist letter. Typically you run through several demands, final demands. You try to give the person adequate notice that they're violating the documents. You could go through the DBPR on arbitration on a nuisance claim. I've never personally done that. But as Dana stated, a lot of times people try to combine it with a secondary cause of action, like a defamation, slander, or libel. And the DBPR does not have jurisdiction over those claims and will reject the entire matter if you bring it that way. Typically, these matters are brought in court. They're brought in court as a violation of the Declaration of Condominium. It can be brought in alternative causes of action. One is a breach of the nuisance provision, and the second as an action for injunction, to enjoin someone's behavior from acting in that manner. I don't like these cases. I don't think judges like these cases.
You said, I'm sorry to interrupt, you said you've done this before, that you have handled these kind of, so how would you handle it, even though it's working in the association, you're a lawyer?
We don't
You're in
know
a
what
situation
you're
where
saying.
these fights calling each other names, board members calling each other, nasty names, how would you handle it? He's the attorney there if you were there present. If you're there, if you're not there, then you're there, how are you going to handle it?
Well, it cuts both ways, quite frankly. If the board members or the association is the one engaging in this horrible, vulgar, vile, abusive, rude language, the cause could go either way, because the nuisance provision cuts both ways in the condo docs, and both sides would have adequate ability to go to court. I'm painfully aware, though, that the association usually